Well, hello again, and today and this week at Kaplan Morrell in workers' compensation land here in Colorado, we've had things take a bit of a morbid turn because we've had to deal with 3 individuals who died at work, and each of those cases kind of present different issues. And one of the weird things about dealing with work injuries, particularly fatalities, is oftentimes how a really emotional and tragic and shocking event can almost be boiled down to sometimes very basic, unemotional little data points. But unfortunately, that's sometimes what the law does. As we're trying to figure out what are the ramifications, at least under workers' compensation, when an employee dies at work. So the first case is a gentleman who worked for a very large retailer who was at work, and apparently he was pushing a cart and all of a sudden just fell backwards. Bang. No flailing of the arms, no slip and fall, no trying to guard. He just went and hit his head. And the blow to the head was severe enough that he actually passed away that day. The family is distraught. The family obviously has a lot of questions, and certainly we're going to see what we can do about answering some of those questions about what happened, etc. But one of the issues that comes up in that particular case is we don't even know if it's covered under workers' compensation. Typically, for an injury, including a fatality, to be covered under workers' compensation, you kind of have to show 3 things. Number one is you have to show that you are in the course and scope of your employment, meaning you are actually engaged in activity that furthers your employment or is a reasonable part of it. Second thing that you've got to show is that something happened or was present in work to cause you to have an injury. That's the third thing. You need to have an injury. And so oftentimes that's pretty basic. I'm lifting a box, it's heavy, I hurt my back. I'm walking down a hallway and there's a puddle of water and I slip and fall on it. But in this case, it kind of comes into what we call unexplained falls. And the question is are unexplained falls covered under workers' compensation? And the Supreme Court has tried to parse out what it means, and typically unexplained falls, even if they can't be explained, are covered under workers' compensation, unless it can be shown that what occurred was something of an entirely personal nature. So for example, if this gentleman had low blood pressure and just fainted, but he could have fainted, anywhere, chances are not covered under workers' compensation. If it had been, it wasn't, but if it had been a heart attack at work, again, would not be covered under workers' compensation. But as with law, the hobgoblins of law are there's always exceptions, and that's why one of the favorite answers of lawyers whenever we're asked a question is, the answer is, it depends. And so if you have a fainting spell just because you get lighthearted because you have low blood pressure and you're on a scaffold or you're on a ladder, you're on a unique hazardous place, and now instead of falling from standing down to ground, you're actually falling from a 4-foot height, then that is covered under workers' compensation because the work combined with that personal condition to make the injury even worse. With this gentleman, we just don't know whether or not they're going to be covered under he's going to be covered under workers' compensation, whether the family will get benefits. But that's story number 1. Story number 2, this is a really kind of horrible, tragic case, again, where somebody's life turns on a dime. And this is a gentleman who travels and as part of his travels, goes to various laboratories to check on equipment, etc. He's traveling, still kind of within Colorado, goes to this city and arrives on a Monday. The following Wednesday, he's hospitalized. He has a bacterial infection, and in 7 days, he's dead. How a life can turn on a dime. And so his daughters, who are in their 20s, contacted us to find out what options they were. And let's put aside the question of, can we prove that the infection occurred at his work or in the course of his work? Let's just pretend that's true, although that's going to be a challenge. The problem was the daughters, all his children are over the age of 21. So they are no longer, by law, under at least workers' compensation's definition, dependents. He's also divorced. He hasn't remarried, so there's no spouse. And so there are no dependents benefits at all, which means that workers' compensation would pay just two things. The medical bills associated with the hospital stay, and they would pay a $7,000 funeral benefit, and that's it. And that's kind of depressing to tell somebody who's crying in front of you, that as far as workers' compensation goes, the limits, the benefits are extraordinarily limited. And if you die on the job and you do not leave children or a spouse, the insurance company is just looking at paying $7,000, and that's it, regardless. Let's go to the third case where there are dependents. This gentleman was breaking down tires in an industrial facility. He was using a blowtorch. The tires were supposed to have been drained of anything in them. This particular tire was not. It exploded. It incinerated him. That's got to be a tough job and a horrible, horrible way to go. This gentleman left two children. I'll call them children A and B. A is 5 years old. A is our client. B is another child from a different mother, and B is 2 years old. When a worker dies leaving dependents, children dependents, the children continue to receive 2/3 of that worker's average weekly wage. So if this gentleman made $900 a week, 2/3 of that is $600. And typically what courts will do, if they're just two children, absent some extraordinary circumstances, they'll just kind of Solomon-like split down that $600 benefit and send $300 to each child. So A's getting $300, B's getting $300. Well, why is it getting complicated? Well, B's mom is saying that she is the common law wife of the worker, and she's making a claim and trying to prove that. And if she can prove that, well, spouses also are entitled to 2/3 of that lost wages, so she'd be entitled to some portion of that $600 for life or until she gets remarried. And so A has an incentive, because this woman is not related to him, to look very closely to see if in fact it's true that B's mom is also a spouse and therefore entitled to benefits. And now, once A reaches 18, then children no longer get death benefits under workers' compensation unless they are enrolled in an accredited school. And in that case, then the benefits continue until the child reaches 21. Once A reaches 21, his $300 then would go to B, so now B would be getting $600 every week until she reaches 18 or 21 if she's in a school. So a little bit of a morbid frame of mind here at Kaplan Morrell, but as you can tell, these cases are complicated, they're fact dependent. If you or anyone you know is injured on the job, feel free to call us or to reach out to us here on Facebook or on our website for a free initial consultation, no obligation. Our telephone number is 970-356-9898, and it's been a pleasure to chat with you.